tarde, bom dia. Eu sou o Igor Castro, sócio do MEC Advogados, e hoje a gente tem mais um podcast da nossa série. O nosso podcast de hoje é muito especial. A gente trouxe pessoas de outro país para falar com a gente, e por conta disso vou mudar para outro idioma. Eu vou falar inglês. So nice to have you all. My name is Igor Castro, and here we have two litigation stars in the US. We have Rollo Baker and Silpa Maruri. Is that correct?
Yes.
Yes?
Right.
Okay. So you are founding partners of Elsberg Baker and Maruri. I'm sorry if I mispronounced your name. And here we want to talk to you. I know you are a very successful law firm. You were launched in 2024, and you were specialized in litigation, commercial litigation, focus on litigations, and you want to hear everything about your firm, about how it is being a U.S. litigator. So I'm very happy to have you guys here.
Thanks for having us.
Okay. I don't know, first of all, if you want to introduce yourselves so the audience can better know you.
Sure. You want to start?
Sure.
Okay.
Hi, my name is Silpa Maruri. It's great to be with you here today.
My name is Rollo Baker, and it's very nice to be here as well.
Okay. So let's start with your story. So you've built your career in very high stakes litigation. Now you have founded your own firm, and it's very similar to our story. So tell us about it.
You want to start?
Sure.
Sure. So Silpa and I were partners at Quinn Emanuel, where we spent a lot of our career. Silpa was the co-chair of the Delaware practice, which was one of the premier practices at Quinn Emanuel. I was the co-chair of the corporate governance litigation practice, not quite as premier as Silpa's practice, but still pretty good. And we formed the firm along with two other former Quinn Emanuel colleagues, David Elsberg, who was the chair of the investment funds litigation practice, and Jared Rocco, who worked with us, and two other partners, Mike Duke and Vivek Tata, who were partners at Slendy Gay Elsberg. And we are litigators at heart, but more importantly, trial lawyers, which is a subset of litigators, at least in the US. A lot of people claim to be litigators, but very few are actually trial lawyers. And what that means is we actually go to trial a lot, and we go to jury trials a lot. And that's where we've made our name in the last 2 years, and that's where we like to spend our time.
Exactly. We are lean and mean, and we do the same job that we were doing at Quinn, and we're aggressive, we're high stakes litigation, and we've had just a great time founding the firm. It's founded on a principle of just making sure that everybody from the bottom all the way up is top quality, top caliber. And, we've proven ourselves time and time again against the big firms.
Okay. And what do you love about going to trial? Because I know you're very famous for going to trial, right? What do you like about it? What is it? Why is it important?
I think, one of the reasons that we really like going to trial is just because fundamentally all litigation is about one thing at heart, which is telling a story. And trial is really your best opportunity to tell the decision maker your story. So why is it you should win, both legally and based on just the equities? Why is it fair for your client to win? And we think that's a place that we shine because we're able to tell the simple story in the best way possible.
And does it involve a lot of preparation?
Yeah, it's a lot of preparation. And what's interesting is that in every one of these cases, $1 billion can be on the line. And you know this as well from your practice. A lot of money can be on the line, but ultimately it's a human that's deciding the case. And ultimately it comes down to two things: a handful of documents, at least in the US, emails or the contract or text messages, and a witness who sits in the chair and looks the judge or the jury in the eye and testifies. And to refine the entire corpus of the case down to what actually matters takes a lot of time and effort and careful thought. And so it does take a lot of time. But in order to be impactful and tell that story, you have to do work to get there. And that work is fun, but it's all the more fun when you're able to tell a compelling story in the courtroom. It's sort of like a sport. You're up there, you're competing, you're having to respond on the fly. It's high pressure, but ultimately, if you get a good result for your client, it's a really rewarding, fun experience.
Here we have a lot of arbitration hearings, and when I started working, my supervisor said, "Well, we don't have you must have a good right, but you have to show a good story." A compelling story, a very well thought and coherent story. And I think the trial is the an outcome of a long hours and months of hard work, studying and reviewing all of the team together. So I bet it's super fun.
It's a lot of fun, and at least in the U.S., most cases don't end up with a trial. Most cases settle, but from our practice and our perspective, it's important to treat a case from day one like it will go to trial, and to develop that simple narrative early on in the case process. And then you tell it every single time you have a chance to be in front of the fact finder. You reiterate those key points because, again, who is deciding the case in the end? It's a human being. And so you need to be persuasive, and you need to find your opportunities to be persuasive, and you need to figure out what your persuasive story is based on the facts, the evidence, and the law as early as you can in the case.
100%. Yeah. Okay. Well, you were talking about evidence and a handful of documents in the trial, but I know, and here in Brazil, we watch the sitcoms about law and all the deposition, discovery. So we don't have discovery in Brazil. So my first question is for you to explain what discovery is or usually is in the US. And then I have follow-up questions.
Yeah, sure. Happy to do that. So in the US, before we get to trial, well before we get to trial, after we decide whether or not there's a legally sufficient claim, we go through this thing called discovery. And discovery is basically different mechanisms to ask the other side for information. One of those, mechanisms is request for production, where you ask the other side to turn over all of their documents. And this can be like millions and millions and millions of documents about everything related to the case. You can also ask them interrogatories, which are basically written questions that they have to answer about every single facet of the case. And then you actually get to go and take depositions. And what depositions are they're sort of like mini trials because they're 7-hour-long examinations where a witness has to sit in a chair under oath and ask questions about all of the facts relating to a case.
Okay, and here for you to have to see how different it is. We don't have any of this. What we have usually that I am the plaintiff, the other party is defendant, and I can produce the documents I want to produce, and the other side produces the documents it wants to produce. There is no obligation to produce internal documents, internal emails, internal WhatsApp message. So it's very different on a general basis. I mean, there are some exceptions. So this is so before going to trial, for instance, you spent many months trying and to try to get into this handful to the key documents, right? And here we don't. And that is an important tool that we here in Brazil can use in a litigation. So the next topic is 782, which I think it's a very good opportunity. But before that, just to make it more clear to the audience, what documents can you reveal in a corporate dispute, for instance? I know for you it may be very obvious, but for us, it is it would be seen as very invasive.
So
Yeah. Sorry. Oh, go ahead. So it can be everything and anything. It can be everything from the formal documents that a company has to emails that were exchanged within the company about the subject matter of the dispute, to even text messages, WhatsApp messages, anything that's on your phone that relates to the case. So it can be extremely invasive to get a document request because it's literally any document that relates to the case.
And there is a process where you try to negotiate the scope. So if you're the recipient of requests, your lawyers will try to narrow the scope and produce a subset of the requested information. But it is always going to be invasive, and it is always a multi-month, if not multi-year process. But the benefit of that process is by the time you get to trial, you have all the facts already set. You understand what the testimony is going to look like at trial, and you have the record.
Okay. And I know your firm and you two are very recognized for cross-examination, your cross-examination techniques. If you could talk about this a little bit more to the audience.
So the benefit of our discovery system is you go through your depositions, and that is 7 hours of 7 hours of questioning of the lawyer, and the lawyer's under oath. Or sorry, the witness is under oath. So the lawyer gets to ask questions for 7 hours. So you then have a deposition transcript, and you know what the witness is going to say. And then when you get to trial, you ask questions in a way that you already understand what the answer will be. And then if the witness departs from that sworn testimony, you can impeach the witness. But in the end, I think in order to have an effective cross-examination, you have to take a high-level perspective. You have to think about not the weeds, but the overall picture, and make sure that your cross-examination is telling a story.
Mm-hmm.
And it has to be a story that the fact finder can actually understand. So if it's a jury, you have to make sure you're telling a simple story, and you have to be watching the jury to see if they're reacting to the questions and answers. And sometimes you might think you have the best possible line of question, but it won't hit with the jury. So you got to let it go, and you got to focus on what matters. And then if it's a judge, again, you got to focus on what matters. But coming in at a cross-examination at a high level first is really important, because you don't want to spend your time in the weeds, because the fact finder won't get the weeds. They'll get the high level picture.
Got it.
I mean, the other thing that's really important to be effective in front of a jury, especially, is just knowing how to use the documents and demonstratives with the witness so that it stays interesting, right? Because, just watching somebody ask a question and answer it gets boring after a period of time. So what you want to do is punctuate your cross with, touch points of things that are dramatic, like key documents that you want the jury to have stick in their head, or key demonstratives that tell the story very clearly that you want them to understand, or, kind of changing the pace of the questioning so that they stay interested. Things like that are also kind of the finesse points in a cross-examination that go beyond just driving home the core points.
And you can also just use sort of, again, I come back to the human element. And that's part of why I love litigation, going to trial, because again, it comes down to the human beings. But you can in a deposition, as I said, you have 7 hours, and you can take advantage of the witness's sort of human flaws. And so I had a deposition once as a senior investment banker in a major bank. He was the key witness. And I could tell he was getting frustrated, and I was asking a simple question, and he wasn't answering it. So I said, I can tell you don't understand my question. I'm going to ask it very slowly. And he tried to fight me on the record. He took off his microphone, came across the table. His witness had to pull him out. And then we waited 20 minutes, came back in. And when he came back in, we went back on the record, and I said, I just want to make sure you're okay. I know this is very emotional for you, and you're having trouble answering simple questions. So then he took his microphone off again, turned his chair around, and the rest of the deposition, his back of the head was to the camera, because depositions are recorded. Do you think that case went to trial, or do you think that case settled?
I don't think.
The case settled, and they wrote a big check. And so that is like using the human element to get your client a really good result. That's not sophisticated. That's not like in the details and the weeds. That's saying that the person across the table from you under oath is going to break, and you find an angle and you use it. And that's a lot of fun too. That also is part of the trial prep, trial strategy, trial work.
I think what I'm getting from you guys is that one size does not fit all. And I think what I'm getting is that every movement, every action in the case file is very well thought, and you think what is the best way to achieve what I want to achieve, and it does not. One size does not fit all. That's what I'm getting for strategic litigation.
Yeah, that's definitely true. And I think you also have to think about how different things are going to come off in court. There's a lot of nuance in terms of who the judge is. If you're trying a case in front of a judge, not all judges are going to receive the evidence in the same way. And so you have to be thoughtful about the audience, right? A judge is going to be very different from a jury. You have to be very thoughtful about how different narratives are going to go over in front of different people. And it affects the way you examine a witness. It affects the themes that you explore in the trial in the first place. It affects the questions you ask. It affects the tone you take with witnesses, that sort of thing. So it's all like, yeah, absolutely. The human element is a big component of a trial.
Okay. there are a lot of elements, and how do you and what I think is that you have to try cases to the more you try cases, the better you get, right? That's what I think it's the key. Try and see how the audience responds to a line of questions, what it hits, what it doesn't hit. So that's why I think practice is very important. Try cases.
Practice is important. We oftentimes will use mock trials for a jury trial, even for a bench trial, or even for an arbitration.
Mhm.
Sometimes we'll do a mock arbitration process or a mock trial for that exact reason you identified. You want to see how the evidence hits. You want to see what works and what doesn't work, so you can refine your strategy, make it more pristine, make it more persuasive for the ultimate presentation. That's something we really have found to be really advantageous.
Yeah, absolutely.
That's great. Well, we don't have discovery here. I've told you guys, we don't. There's no discovery here in Brazil, but I know there is discovery in the US, and there is 782. So if you could tell us what is this tool, and how can we use this, and if a Brazilian company can use this, it would be very helpful.
Sure. 1782 is a statute. It's a bill that was passed in the United States that allows foreign litigants to come to the United States courts, federal courts, and seek discovery. And the requirements are that the discovery that is being sought must be in aid of a foreign proceeding. It has to be a litigation, not an arbitration, based on a Supreme Court ruling from a few years ago. And two, the discovery sought has to be obtainable by an entity that is within the district in which the court sits. So it's pretty low standards in terms of satisfying what you need in order to get the discovery. But if you do that, it opens the door for US style discovery, broad document discovery and broad deposition discovery. And we have worked with Brazilian clients in Europe, clients around the world in order to bring 1782 proceedings to open up a new front in an ongoing dispute that is abroad. And sometimes the objective is not even, sometimes you understand that it might be hard to get the full discovery you're seeking, but it allows you to go to that forum, or the US forum, try to get the discovery and also tell your story in a different forum and see if you can change the overall dynamic of the situation, because sometimes those documents you'll get are going to be case shattering back home in the foreign jurisdiction where you can't get that type of discovery.
So if you have a 782, you could have a deposition of an employee of the company who lives in the US, or the CEO. I mean, that I don't know if you have any specific case that you could tell us about what documents you are seeking, and just to showcase the audience how powerful this tool is.
Sure. There was a case, I can't talk about the specifics, but there was a case where we had an Indian client, and the Indian client wanted to use 1782 based on the fact that this was a multinational corporation which had operations in the US. And the first step was pursuing documents and eventually potentially depositions. The document discovery itself is pretty high pressure because of the expansive nature of US style discovery. So the company has to turn over potentially tens of thousands, maybe hundreds of thousands of documents in aid of this foreign proceeding. And that in and of itself created enough pressure in that situation to cause the parties to talk to one another and to bring them to the bargaining table in terms of a settlement.
Okay. Well, what I think it's great is that the Brazilian audience should know that whether you want to use it or whether you want to defend against it, you have to be aware of it. And if you have to, if you either want to file or defend, you need to hire lawyers who know what they're doing and who know how important and broad is discovery in the US.
It's absolutely broad. It's absolutely a powerful weapon. We've had cases settle because a party doesn't want to comply with an order from a US court to produce text messages or WhatsApp messages. But it's also important to know that it can boomerang. A lot of people don't realize that. Sometimes a court has a discretion to say, I'll give you the discovery you're seeking, petitioner, the person that is bringing the 1782 proceeding, but you're going to produce discovery as well. So that is a risk that most people, in my experience, don't really appreciate. And so that's something clients should know as well, is that is something that can happen. And so you want to make sure your house is clean as well. And there is case law that suggests that discovery doesn't even have to be located in the district. It could be discovery located outside the district, and it can be a condition that you have to comply with two-way discovery in order to get the discovery from the party that's actually in the district.
Yeah, and the other obvious risk is you're subjecting yourself to personal jurisdiction in that court, right? So you may say, oh, I'm going to serve 1782 filings in Florida. And all of a sudden you filed something in Florida. And so the other side could file something against you in that jurisdiction as well, depending on what it looks like.
I will say, and I think you probably agree with me, that boomerang risk is a low risk, but it's a risk to be aware of. That typically does not happen. Typically, the way a 1782 proceeding unwinds is that the party that seeks the discovery will get the discovery, and the party that's opposing the discovery doesn't think to ask for boomerang discovery.
Nice to know about. And this, all these implications of a personal jurisdiction. I know Brazil would say our legal system is very complex, but any jurisdictions, you have to be aware of the risks of litigation in any jurisdiction, right?
Absolutely, because the last thing you want to do, for example, is be a Brazilian company and all of a sudden you tried to create leverage and now you've got a full-blown litigation going on in the US against you that you didn't count on.
Let's talk about something different right now. And it's AI. Everybody's talking about it, and it's changing how work is done. And I want you guys to tell me: are you using AI? Do you use AI? How are you dealing with this thing?
Who's not using AI? Right?
Yes,
Everybody's using AI in some form or another. So we do. There are probably two components to it. Maybe I can speak to the legal component and you can speak to some of the other ways that we're deploying it at the firm. So from a legal strategy perspective, we do use it. One application of it, probably the most obvious application, is it's great at doc review. So once upon a time in the US, because you get millions and millions and millions of documents, you used to have humans reviewing these millions of documents that you get in discovery. Well, now you can use AI to review the documents, and they can go through the documents at a fraction of the cost, and they can also go through the documents much, much more quickly. So AI is a very powerful tool for that, and it can sometimes find a needle in the haystack that a human reviewer might miss. And, the preliminary sort of industry research suggests that it's fairly accurate. It's not perfect, but human reviewers are also not perfect. So it's a pretty good tool. Another way that we've used AI really successfully is just idea generation. So let's say you get called in to do a pitch or to do an argument or whatever it is. You can kind of use AI to think about different ways to present material, which can be very effective. Obviously, you really have to carefully check the results of what the AI is spitting back to you. An example of that is I recently had to do an oral argument, and Rollo actually said to me, oh, you're working on this slide deck. You should see what AI says in terms of refining some of your slides. And it was great. Did I use what the AI spat out? No, but it was great to get that feedback. It was almost like getting feedback from another person and then deploying it and refining what I had put together to make it better, more simple. So that's, just a couple of examples of how we've used it, but we also use it in other ways as well.
Yeah, so our CEO, Josette Winograd, has sort of been very focused on how we could use AI to support us from a business perspective. Silpa was talking about it from a legal perspective. But for example, things like developing background materials on potential clients or on market trends, or if we're meeting with someone like you, your bio, it can pull all that information together pretty quickly and efficiently, and we're using that quite a bit. And then we're also using it for sort of administrative tasks like setting up meetings or countering meetings. I don't know how that works, but I know we're doing it. So we are trying to implement it. We are implementing it, I think, successfully because it is obviously a way to cut costs and be more efficient, and it's sort of where the market's going.
I think it's really good to talk to you about this because the first part that you were talking, Silpa, I mean, it's something that we here are discussing and using. But the second part, I think it's something that we could uh, focus more, and I think it's great. I mean, I think the question now is not whether to use or not to use AI, but how to use it, right?
Yeah,
It's
it's
it's a
definitely a game changer, and it saves time, and I think it's going to be particularly useful for boutique law
yeah.
firms where leverage isn't the entire show. And I think teams that are efficient and know how to use it, interact with it, can really thrive with it. It does reduce, I think, some of the need for leverage. So some of the traditional models may not be as desired compared to a model that relies in part on AI.
Yeah, and I think that, and it leads me to my next question because I think people, senior people, they use easily in the way that you just said. Well, it's to double check, but I have to check everything. It's just to brainstorm. But maybe people who are more junior, they may not be as careful as we are. So my question is whether you train the junior associates and make sure they use it correctly. I mean, or if they are using or if you're not having any problems with this kind of use.
Yeah, so we definitely. So first off, in the U.S. at least, it's not junior associates that are getting sanctioned by the courts. It's a lot of more senior lawyers that are making mistakes. We have not been sanctioned, and we're not using AI to write briefs or anything like that. But we have had a number of discussions with our entire firm to make sure everyone understands the risk, and then we also illustrate that risk in real time. Because anytime you use AI to try to come up with an argument or a legal argument or to review a brief and respond to it, you will almost always find examples of hallucination. And to see that in real time and to see how confident that AI output is, and you read it and it makes perfect sense, it's the exact argument you want to make, you're like, I'm going to pop that in the brief, and then you go to check that site and it's wrong. It doesn't exist. And so when you see that in the flesh, I think you sit there and you're like, okay, I do not want that to happen to me. So I am not going to just rely on AI. And so we reiterate that with everyone at the firm regularly. And, if anyone makes that mistake.
Yeah, that was a great idea to show in real time what happens. And what I usually say is that sometimes AI say something very wrong, but in a good and perfect Portuguese language or English with so confidence that if the person is not senior enough, they're gonna believe it, and I know that by if you were the senior we can say that's wrong, that's not what I think it is. But I think it's a great approach you're taking.
Yeah, I would say the junior associates, we don't really need to train them on how to use AI because they're better than us at using it. What we need to train them to do is learn how to be critical thinking lawyers. That's kind of like the thing they came to the law firm to learn how to do better. And so I think that's more just a matter of not, sort of blindly relying on AI, just the same way you don't blindly rely on a treatise, right? Once upon a time, you could go look up a treatise and it said something, but oftentimes it oversimplifies the law.
Yeah.
So it's just another application of the same skill set you need as a lawyer.
Critical thinking.
Yeah.
And I think the best litigators, they have good critical thinking. Yeah. Okay. Thank you. I have questions for you guys. If you wanna talk about a case that it shows how it is to be a U.S. litigator, in case that you think it shows your firm's DNA, way of working, I'm eager to hear.
Sure.
Why don't you talk about Jane's.
Okay, so I'll tell the story briefly, but I have to leave out certain portions because it's confidential. But last year, we got retained to represent former portfolio managers of a proprietary prop trading fund called Jane Street, who were being sued by Jane Street, and they were being sued alongside Millennium, which is a multi-strat investment hedge fund type entity in the U.S. And it was all about trade secret misappropriation. My former firm brought it. They saw a TRO, a temporary restraining order, and we were the defendants. And typically, when you're a defendant, what do you want to do when you're facing a TRO? You want to slow things down. You want to pump the brakes. You want to draw it out. You don't want to get to a hearing. You want to tell the court it should all be on an ordinary schedule. But we felt very good about the merits. And so not only did we put in extensive fact witness declarations in opposition to the TRO, we sought a even more expedited schedule because we wanted to get to the merits as soon as possible.
Very aggressive.
And that was our overall strategy. We defeated the TRO in the Southern District of New York. And then we continually pushed to get to a merits hearing as soon as possible. And that is not a strategy that a lot of law firms would use, but we felt it was the right strategy given the facts of the case. And we thought that resulted in a benefit to the client. I can't say anything beyond that.
Okay. And how were you able to get into the facts that quick and be confident that you had good facts on your side?
So again, I can't talk about really the facts, but what I'll say is we were confident in our strategy because we did the work from day one. We had a team that came together. I think we got the case was filed on a Monday. I don't think we went to bed until Friday. It was about 6 of us working around the clock, speaking with the witnesses, getting the documents, looking at everything. Wow. And doing that work. And you might say that sounds like a miserable thing not to sleep for 4 days, but for us it was like a dream. That's what we love doing. We love that hard work. We love putting in that effort and then getting a good result.
That's nice.
Yeah. And the answer is really just Rollo's amazing. So
and does not sleep.
Yeah, Rollo's amazing and does not sleep. When there's, affidavits to be done.
I was sleeping the entire time. It was AI.
Okay. Do you want to talk about another case or?
Sure. I think the general playbook that Rollo discussed, where we just get in, and dive neck deep right away and immerse ourselves in the facts and just repeatedly tell that story over and over again to the fact finder, is just something we do in every single case. And I think the reason why we tend to beat most of our adversaries, even adversaries that are bigger than us or more well-known than us or whatever it is because we really do steep ourselves in the facts, find the story, and then tell it in a very succinct and simple way. So right now, for example, we have a case where we're litigating a fraud claim. I'll be pretty generic here because it's an ongoing matter. But what we did before we filed the claim is we looked at the facts and we determined that there was real fraud here. And we were very careful before we made that filing to understand exactly how the fraud was perpetrated. And as a result of that, by the time we were in front of the court and telling that story, we had a very compelling narrative. And that's really what you want to be doing every single time you're in front of the court. And so every single time we've been in front of the court, discovery motions, just status conferences, we've been able to talk about what the real deal is in terms of the things that the court should care about. And that is true of all of our cases. We really try to do that storytelling across the board.
Okay. And I think that to be able to determine what is key and to make this story succinct is very hard. Like it demands a lot of hard work. So
hard work and skill, and what Silpa was just mentioning, that works. Like that model works, and Silpa's had a tremendous amount of success deploying that model, using that model and using skill and deposing a name that everyone would understand or know immediately over a 3-day period. She led the team and secured $1 billion settlement which was the largest settlement ever in Delaware Chancery Court for a class action. So that doesn't happen without skill, hard work, and telling a creative story that is backed up by the evidence and the facts.
Great. Okay. So my final question, and then we close, we end the podcast, is we talk a lot about litigating and about lawyering. And if you could give any piece of advice to young lawyers in the US or in Brazil, what would it be?
My advice would be for you to lean in from day one, because I think a lot of lawyers, when they start their career, are too passive about pursuing opportunity. And what they do is they expect to show up and just be fed work. And that's good. You should do all the work you're assigned and you should do it the best possible way you can. But you also need to ask for the right opportunities, because if you don't ask for the right opportunities, sometimes the more senior folks don't necessarily have that on their radar. And so I think every single lawyer, when they start their career, is well served by being sort of aggressive, doing a great job, and coupling that with asking for the things that they want, whether that be opportunities, whether that be meeting the right people, whether that be getting the right type of work. All of that, I think, makes a huge difference in your career trajectory.
Okay.
I echo that. I would also say, I would say two other things. Get comfortable with uncertainty. When you are a young lawyer, if you are doing a good job, I think you oftentimes will feel like you don't know what you're doing. And it is true, you don't. You're always learning. And so you have to be comfortable with that feeling and know how to deal with that feeling. And to deal with that feeling, you have to dig in. You have to double check your sources. You have to read the treatises. You have to ask questions, and you have to tell the folks you're working with when you have doubt. But then you have to say, but here's how I'm going to try to resolve that doubt. So you need to be uncomfortable living with uncertainty. In a lot of the cases you do and we do, it's uncertain. The law is uncertain. The outcome's uncertain. The facts are uncertain. You're trying to figure out what's going on. So you have to be willing to live with that. The other thing is focus on the task at hand. Don't focus on, what next year or 2 years are going to look like. It'll work out if you do the hard work, if you stay humble, if you're eager, if you take agency over your work, it'll work out. So don't sweat whether you're, at any moment in time checking the right box in terms of career development. Focus on one task at a time, but at the same time, be aggressive, ask for opportunities, and be your own advocate.
Right. Yeah. What I was thinking is that on top of that, if you want to work with litigation, I think it's good if you work with people who are passionate about it, because passion drives long hours, drives doing the best you can for your client and reviewing every document to find what I need to find. And I think working with passionate lawyers in litigation is important as well.
Yeah, because sometimes it's dry and you need somebody who can find the fun even in something that's dry, because otherwise, you really can just sort of make things mundane, right? I think your attitude matters a lot. And people who are passionate are usually more fun to work with.
Great. Okay. Well, thank you for having me for coming and joining this podcast. I'm pretty sure it was very helpful, and it brought a lot of different perspective to our audience. So thank you for coming.
Thanks for having us.
Ok. Bom, o podcast de hoje acabou. Espero que tenham gostado. Fiquem ligados para os próximos. Muito obrigado.